Hi everyone, welcome to our new chapter, the most interesting, very important chapter for our other law syllabus. And you can say very important and very necessary for every chartered accountant, every professional like a company secretary or a cost accountant must understand this chapter and go ahead in future. Before we go ahead with our this particular chapter, as on the screen you're able to see, the screen speaks about interpretation of statutes. So yes, ma'am. Ma'am, are we going to study this chapter? Yes, exactly. We are going to study this chapter now, that is interpretation of statutes. What does interpretation of statutes speak about? What is this, ma'am? Is this an act or what is it? No, for your good information, this is a chapter. And for better understanding, it is important to remember, understand, revise this chapter more effective way. Ma'am, why, ma'am? All the chapters you're saying it is important. No, I'm saying you this chapter is very important because from this chapter, maximum 10 to 12 marks are being asked every term. I'm saying maximum 12 marks. They can ask you 8 to 10 marks also, 10 to 12 marks, in between 10 to 12 marks also, they can focus on. So it is very important for you to understand this chapter. It is not a lengthy chapter, but it's a big chapter bit because we have things to understand. What is to be understood? We have to understand the law. We have to interpret the law. We have to um, properly define the intention of what the lawmaker is wanting to speak. I wanted to say one thing, that this chapter is done after General Clauses Act 1897. Why? Because in General Clauses Act there was a small brief on interpretation, but now this chapter is speaking totally about the interpretation of statutes. Going ahead with this chapter, I would like to say that interpretation means what? What is interpretation speak about? Interpretation means, ma'am, interpretation means like there will be a sentence given and you have to interpret or you have to find out what does that sentence make you understand. So, so let please write down this small point. Interpretation means the process of application application of mind. The process of application of mind means when there is a particular phrase or a sentence or a 5 6 para which is speaking something, what are you able to interpret? For example, I'll say that um, there is life is like ocean. Life is like an ocean. Every day is an ocean. Life is like ocean. Every day is a new chapter for us. So what do you interpret on this particular sentence? You have to interpret in the way the person who has written this sentence wants to make you understand. For that, what is important is interpretation actually means what? It means it is a process of application of mind. You have to apply your mind on that particular statement, on that particular language, and then you have to express it what actually the statement wanted to make you understand. Okay, so what for? Application of mind for what? For what? To find out, to find out the true sense of the word expressed. Okay, expressed, and there is some word which has to be written. I'll tell you what is it. So what understood? Did you please make a note of it? What does this say? This say about. So what does it say? Interpretation speaks that interpretation actually means what? In English language, interpretation means it is a process of application of mind. Okay. Now, if you understand interpretation in the language of law, what is it? When you are applying your mind, for what you're applying? To find out actual meaning of it, right? To find out the actual meaning or the true sense or the actual meaning of the word expressed in the statute. In the statute. Now I'll tell you what is statute. Normally, statute is being told in many words. Normally, it is said it is a law, it is enactment, it is act. Okay. Normally, people say for approximately, you can say it is law, it is enactment, it is act. Okay. So, what does it say? It says that what is interpretation of statute speak about? It is saying it is a process of application of mind. For what you are applying the mind? You are applying the mind for finding out the real meaning, the original crux point of the words expressed in the statute. Statute here speaks about law. It can be enactment, it can be act. Got it? So statute, normally statute is the word which is not normally used by people. Okay, what normally statute normally people use is the word law. Okay, so that's what I'm saying. Statutes approximate meaning is law, enactment, and act. Approximate meaning is law, enactment, and act. Okay, fine, understood. So what so you can also understand that statute is a law or an enactment or an act. Now, what is act? As I have already explained in the uh, first day. Yes. Now we understood the word what is interpretation. So what it says, interpretation of statute means what it says about it is interpretation means it is a process of what is it? It is a process of application of mind. Okay. Why do you apply the mind? To find out the real meaning, real sense of the words which is expressed in the act or the enactment or the law, right? That is called statute. Now, let's understand what is act. First thing, as I already have told you in the introduction lecture or the first welcome lecture, I'm just going to that slide now. Okay, so I hope you are able to see the screen. Okay, this is how is act formed. Okay, how is act formed? Now act is formed with act is formed how? First thing is there is a bill. Okay, this bill is a draft law. Okay, this bill is a draft law, and this draft law or this draft law is to be accepted by the Lok Sabha or the Rajya Sabha. As in when from Lok Sabha and Rajya Sabha there is an approval, it goes to the president. As in when there is assent or acceptance of this draft becomes a bill. This draft, this bill will be an act. This draft bill will become an act. Now, if it is being given, for example, it is being given that there is a date on which it should be mentioned or it should be given to the public. Now, for example, I have already shown you, but still I'll show you that e-gazette. Okay, e-gazette. There is e-gazette website. Okay, now when we go to e-gazette website, yeah, this is the e-gazette website. I hope you're able to see the screen. Okay, so here you are seeing, you skip the main content. Okay, you put, and here if you are able to see my screen which I am showing, this is saying this is the page of the e-gazette, means it is the official gazette, means it is a website of the official gazette where your acts will be declared, where your rules, notifications, circular, everything will be properly mentioned, and it will be mentioned to the public so that from that particular date it will be on force. Okay, so here if you see there is bills and acts. These are different. See, you're able to see, these are what, these are bills and acts. Now I go back. Here if you see there is state gazette, there is rules of it. Okay, and many other things you have. Okay, all the things which will be mentioned, it will be properly mentioned. If for example you want to find out any weekly gazette, means you have anything you want to find out, submit, you do, there will be a weekly gazette, means this particular gazette is saying on this particular week, you see section 18 December, 18 December, issue date is 18 December, published date is 18 December, and if you download it, this particular notice or that particular gazette information will be on. Okay, so this is how this particular website works, and this is the very important website which gives you notifications, which declares about the rules, about the acts, about different bills which have been initiated. See, everything is being given. Ministry of Minority Affairs is there, there is some subject related to it. If there is any notice, if there is any circular, see, publication of notification, if there is any rule to it, every single thing will be mentioned. Why it will be mentioned? It will be mentioned to have a clarity and the general public can also watch it. Okay, now, here it is given the act will be mentioned. This act in the official, there will be a date mentioned, and in that date it will be mentioned or the published in the official gazette. If the date is not mentioned, as and when the bill has become the act, on that particular date, remember, I'm saying what? It is saying that if this bill will become act, okay, this bill will become act. And as and when it becomes act, there will be a date given. Okay, there will be a date mentioned, and that date, on that date, it will be mentioned in the official gazette, which I showed you the website. Okay, but if it is not mentioned, if on that particular there is no date mentioned, then on the day when this bill, when this draft bill became an act, that date will be declared, or that day will, it will come into force. Got it? I hope you understood how act is formed. Another point now. Now another important thing, how is law formed? Law is formed with these things. First is act, then there is rules, then there is circulars. Please make a note of it. It's not there in our book. Then there is notifications. So what is this, ma'am? Yes, these are the main ingredients of law. Ma'am, law also has ingredients. Obviously, every particular topic, don't you think law is a bigger, vaster term? Okay. So to make a law properly understand, read, to properly be read or understood or interpreted, there are things which are joining hands together to make a proper law. So act is important. As you know, act is formed in this way. Okay, so there can be act which can be formed by state or the parliament. Okay, next there are rules. What are rules? Rules are there to give a clarity on the act. There are some acts. Okay, for example, there is you know cost audit act. Okay, think there is example cost audit act, and there has come new rules on the cost audit rules. Okay, which has come. So what does this rule? This rule gives you more specific interpretation on the act, what the act wants to speak on. So the rule and act are necessary. Now, for example, Act has told that example, okay, Act has told that the cost audit, example, the cost audit should be completed within 60 days. Okay, and now suddenly there has been a rule of the cost audit rules which has come. This cost audit rule has said that for the manufacturing industry, the cost audit should be completed within 50 days. Okay, so when there is a issue or when there is a problem or a ambiguity or a confusion between these two rules, then what you have to do? You have to make sure that you are only taking the act's meaning, because rule has been assigned or it comes under the act. Act is the superior, rule comes under it. Got it? Understood? Now next comes is the circular. What is circular, ma'am? Circular means what? Now for example, you are studying in school. Okay, you must have studied in school, and in school, no, sometimes what comes is ma'am is teaching, and in between some peon gets a paper. Okay, a paper, and that paper has something to be announced. Okay, and ma'am starts reading on it. What does it speak? It speaks that it is a circular. Example, huh? It is a circular means there is some specifications which it wants to announce, it wants to declare to the public. In circulars it will be declared. Then comes notification. Time to time there will be different notifications according to the law, according to the act, according to the clauses, according to the title. These notifications come. Okay, so in short what I'm saying is law is a combination of act, rules, circular and notification. All these combine and bring you a proper law. I hope you understood. Fine. Okay, now so let's go into the chapter. First thing, what I would like to say is let's go to the chapter and then we'll understand what else to be read. Okay. So open up the chapter interpretation of statutes. We are in page number 112. Okay. So now this interpretation of statute speaks about why, how, what is the real meaning of the law. Okay. Okay. It is giving you a main point of understanding why the lawmakers have done it. How do you read this law? And most importantly, for your good information, this chapter was there in CA final level. But suddenly they have found and they thought of putting this chapter in the CA inter level. Why, ma'am? Why, ma'am? Why we have to study so much? We have so many subjects. We have so headache with those subjects only. Why again this chapter? If this chapter would have been deleted, it would have been good, ma'am. No, no, no. Trust me, whatever the CA Institute has done for getting this chapter from CA final to CA inter, this is the best thing they have done it. Why? Because in the inter level we are going to understand the and learn the law. Do you think the law language is that easy? No, it's not easy. If you think that the law language is just English, ma'am, we can understand. No, if it would be English, all the engineers, all the English graduates would have also understood law. If it would be only in English and only just of interpretation, then why there will be some millions of cases, lakhs of cases every day, and the court is just revising or finding out time to close the cases. How? Why? You say me think on it. This means that the interpretation of law is in a bigger term. The lawmaker has given you a language, and it is finding, if you are finding that language to be difficult, then there comes difficulty, or there comes problems, there comes issues with one or the other party, and there comes cases. Okay. Now, as a chartered accountant, as a company secretary, as a CMA, this particular chapter is very, very necessary. Ma'am, because it is there in our syllabus, is it necessary? Yes, it is necessary for that point. Second, to make your concept clear and to understand law in a very good way. And after passing CA, CMA, CS, if you are reading law, if you are going through law, you need to interpret the law. Okay, you need to understand the situation, what the lawmaker is wanting us to understand. This is why we have to read. This is why it is being put in our CA inter syllabus. Got it? Now let's go ahead. Interpretation of statutes. I'm just giving you a brief thing. Okay, then we go into the chapter. What are the things which we have to study? Interpretation of statutes is the chapter. Okay, this is not an act, it's a chapter. This chapter has these, this is the layout of this chapter. First thing we'll understand is the relevant terms. Means relevant terms here means what, ma'am? Means about statutes which we understood, we will read it. About deeds, what are documents, we have to understand. Ma'am, is it necessary? This is very, very, very important. If you ask me as a teacher, I'll say you obviously these 3 points and what is interpretation, these 4 words are very, very important. Normally people take it granted. They feel that why should we read these words never question comes. But if you understand the main root of why we are reading this chapter, this particular words are important, these words are required. Okay, next we have, this is the first one we'll read. Second, we have the need, like what is necessary of interpretation of statutes, why is it required. Okay, third, we will understand the very important part, that is primary rules and the secondary rules. Okay, primary rules has I have made a shortcut of it, that is herbal means these are one is the rules which we will read in the later of the chapter, don't worry. Secondary rules also we'll read. Next comes the aids to interpretation. What are the related aids required for interpretation? It can be internal aids, it can be external aids. Then the last we will understand is the rules of interpretation. There are some various ways of understanding, that is the rules. There comes the rules, which I said you rules are important, so that it gives you an and clarity how do you understand it. Okay, now let's go ahead. What as I said you, this is required for what? This is required, see, let's read it. What is there? As a chartered accountant in practice or service, you are required to read various laws, as I said you, and statutes. Okay, often these enactments may be capable of more than one interpretation. Means it is saying that there are acts, there are statutes, and in that statute there will be some particular sentence given. Okay, there will be sentence given that that sentence can give you interpretation in two three ways also. So it is in this context that the awareness of interpretation as a skill becomes relevant. So here what is meaning is in this chapter this becomes a skill and it is relevant. Okay, nothing, this is nothing to like mug it up, but this is an important chapter, everyone, boys and girls, important chapter, mark it. And I request that you have to read this chapter before exam. The first you have to revise this and then you go to the later of the other chapters. Okay. Okay, what does this chapter say about? This chapter will enable you to understand certain rules of interpretation as well as the various internal, external aids, as well as different principles, different rules on it. Okay, we shall discuss the art of interpreting the deeds and documents. Same thing which I said. Okay, now what is the meaning of statute? Already explained. Now I'll say you. Statute, it has been defined. Statute has been defined as a written will of legislature. Ma'am, you said me something and this is something. Yeah, obviously, I'll tell you what is it. I said you the normal meaning. Okay, now I'm telling you what is given in our law. Statute is defined as a written will, means it is a written document. Okay, and of the legislature. Legislature means it which is coming from the legislative power or the constitution. Okay, legislature comes from the word constitution. In constitution you have three parts: legislation, executive, and another part is there. Okay, so the statute is a law. Yeah, as I said you, statute is what? It is a law. It is an enactment established by the act of the legislative power. Established by the act of the legislative power. By the act of the legislative power, this statute is being established. So hence statute, for approximately 95 to 100%, you can say statute is a law. Okay, understood? Here the Constitution of India does not use the term statute. As I said you, why statute is not used? Statute is not normally used because normally it is not being understood that easily by the people. Hence they are using the term law in case of statute. Okay, in case of statute they are using the term law. So what it says, as I said you, law includes the ordinance, order, bylaws, rules, regulation, notification, custom, usage having the force of law. So what does law say? Law here, as I said you, the main concepts is law is a combination of act plus rules plus circular plus notices. With this there are inclusions, that is regulations plus bylaws, okay, and ordinance. Fine, got it? Understood? If you would have observed one small thing, these words were somewhere read, no? Remember, you have read this word somewhere. Can you say me where? Ma'am, we read it in the GCA chapter where it says about the provisions of the orders, notifications, then regulations, rules, and bylaws, forms, and schemes. We have read this, ma'am. That's what it is saying, that law includes these. So, if you understand, this is an inclusive meaning. Inclusive meaning. It is not directly saying law means. Law is including these all things which I already explained you here. This thing. Fine? Understood? Now, let's go to the third point, which originates through the legislation called the enact or the statute as against the unenacted or unwritten law. So it is saying that it is originating from the enacted law, not required, not that required. In short, statute signifies what it signifies, a written law as against the unwritten law. So this can be an MCQ. Just mark it. So I hope you understood what is statute. So this particular point of understanding is tick. Right? Done. So we are done with the first checklist. Next, going down, let's understand. We are going slowly, pacefully, but we are understanding everything. Now, what is the meaning of document? Ma'am, this meaning of document we have read somewhere, ma'am. In GCA we read, no? Remember in GCA, the meaning of document was there. In section 3, it was there. Remember? Let's see what is there in this chapter. What is the meaning of document? Generally, what is document? Document is an evidence or a proof, right? Right. That's what. It is a paper, or you can say document is a hard copy. This hard copy ensures evidence or truth of a situation. Right? So what is saying, generally it is understood. How it is understood? Generally, it is understood that a document is a paper or other material thing giving information, proof, or evidence of anything. What is document? Now, for example, I will give you a receipt. I'll show you a receipt. And do you think it is a document? Yes, ma'am. The receipt is a document. What does it say you? It speaks that you have done a purchase of 2000 rupees and that bill has been shown, and it is giving you a clarity, or it is giving you a proper information that this purchase was done in this particular shop on this particular date, and the purchase was about a gown. Got it? So this is what an example was. In simple words, it is a formal legal document. It is a formal legal document which is enforceable in the count of law. What it says, it is saying that it is a legal document which is enforceable in the count of law. Means for understanding, for taking a proof in the court, this document is necessary. Okay, it is necessary. See, here it says what? Example we'll see, and then we go down. Section 3 of the Indian Evidence Act states document means any matter expressed or described upon any substance by means of letters, figures, marks, or by more than one or those means intended to be used or which may be used for the purpose of recording that matter. Okay. So what it says this particular is being defined in section 3 subsection 18. Recalling section 3 subsection 18, definition of document speaks what? In GCA 1897, it states what? It states that the document shall include any matter written, expressed, described upon, or any substance by means of figures, letters, and marks, or more than one of the means which is intended to be used or which will be used for the recording purpose. This particular example is speaking about the section 3 subsection 18 of the GCA 1897. Okay. Now, as already given here, letters, figures, marks, and more than those which have been intended for what? For recording purpose. Okay. Now, the very important question can be asked: what are the key elements for a document in interpretation of statutes? IOS, I'm saying, is interpretation of statutes. So to make it easier, okay, don't write IOS and come in exam. Okay, IOS I'm just saying for our class or for this recording. Okay, so what are the elements for the document in iOS? So what are the elements? It is matter, record, substance, and means. Okay, let's understand matter. The first element, matter, the first element, it uses its usage with the word any shows the definition of the document is comprehensive. It is saying its usage with the word any. It is saying any means it is giving you a comprehensive definition. Okay. Next, substance. What does substance say? It says about which is mental or intellectual element comes to find out the permanent form. It's saying about the permanent form, whether it is a mental or an intellectual element. Okay, what does the record speak? It must be certain mutual or mechanical device employed on the substance. It must be written, writing, expression, or description. Okay, record can be of writing, description, or expression. What does mean speak about? Mean speak about. This represents the fourth element, which by which such permanent form is acquired, and those can be in letters, in figures, marks, or symbols, which can be used to communicate between two persons. So what does mean say? It says about that particular permanent form, the form, permanent form, which is giving you an information about letters, about any figures, about any marks, about any symbol. And it gives you that there is a communication between two persons. As I gave you one example, that example says what? That example speaks about that example speaks about what? Example speaks about a receipt, and receipt is a proof when I had the particular purchase, at what time, that there is a digit, there is a figure on it, there is a substance on it. Okay, the first element, it says about the document is comprehensive. What is the matter of it? The matter is there is a receipt. Substance means there is a permanent form of it. What it records? It records in writing, expression, and description. Means it is a gown. The gown is one gown or two gowns, and it will be written about the date. Everything will be properly expressed. That particular receipt gives you a communication between two people, when it was done, why it was done, like was it done or not. So it gives you a proof, evidence. Okay, done, understood. So what are the keywords you have to remember? The words you have to remember is the matter, and matter here is comprehensive. Substance is always permanent. See, how do you remember? Matter, okay, this is written already. I'll write it here. Matter is comprehensive. Okay, substance is permanent. Record is writing, expression. Means like letters, symbols. Okay, so if you remember this particular thing, it will be better. Okay, fine. Now going down, what is the meaning of the term deeds? Okay, what is the meaning of the term deeds? Now, what is deed? Deed is an instrument in writing purporting to effect some legal nature. Means deed is what? Deed is something, a statement or an instrument. It is an instrument. This instrument is doing what? It is in writing. First thing, it is in writing. Like for example, agreement deed. Okay, now you have an agreement deed. This is an agreement deed. What it is saying? It is saying that there are two people which are getting involved in this particular service, and you have to do your signature, right? So what it says, it is purporting, or it is giving you a legal sense to it. Legal sense to it. Okay, so deed is an instrument in writing purporting to effect some legal nature. What is it? It is an instrument but made for a service purpose. For example, as I said you, there is an agreement deed between the agent and the principal. Remember the agency contract. Okay, there can be an agreement deed between the for the purpose rent, between the tenant and the owner. So for what purpose? For the service purpose. The service purpose here is rent. Okay. So next, simply states that deeds are instruments, though all instruments may not be deeds. It is saying that all instruments cannot be deeds, but deed is one type of instrument. Understand this language? It is saying MCQ can be asked. What it says, that all the instruments in the world is not deed, but deed is one type of instrument. Okay. So next, however, in India, no distinction seems to be made between instrument and deeds. In India, it is said that sometimes instrument and deeds are to be recorded or understood in the similar way. There is no distinction. Okay. So here, what is the crux point is, deed is an instrument. 2 points, instrument. It is helpful for service purpose, and for making it a legal in nature. These are the keywords you remember. That's it. Fine. Now coming to the main point which we already read, meaning of interpretation. Now if you read the language of the law, you will understand. You say, ma'am, it's so easy. Yeah, it's easy. Why? Because I already explained you. We are reading it the second time. It should be stored now. Okay. What is interpretation? Interpretation is the nature by which the real meaning of the act and the intention of the legislature is enacting it is ascertained. What is it? It is saying that it is giving you the true sense of the act. True sense of the act. Okay. So interpretation here. Interpretation may be either legal or doctrinal. Okay, it can be legal or doctrinal. Question can be asked MCQ. Interpretation may be legal or doctrinal. Is it true or false? Okay, it can be said that interpretation may be either legal or unlegal. You have to say true or false. You have to say false. Interpretation may be either legal or doctrinal. The words are important. You can't interchange the words and say it is correct. No, even if the meaning speaks same, but you have to understand properly and write. Okay. Okay, now it is legal. We are going to understand when it is legal, when it is doctrinal. It is legal when an actual rule of law which binds the judge to place certain interpretation of the statute. It is legal when there is actual rule of law and there is judge coming in between and making it properly interpret about the particular act. Okay. Now, for example, there is Mr. Lal versus Mr. Shal. Okay, there is Mr. Shali. Okay, Mr. Lali versus Shali have an problem, and this particular problem has made them suit a case. And here this case has been done legally, and because there was a agreement deed, there was a deed done. So that was absolutely easier for them to case for suit a case. And in this situation, what has happened is the judge is going to open the book of the act and understand the interpretation of that particular act and give a proper conclusion to it. Understood? Okay. Now, what is doctrinal? Doctrinal is when it is purpose to discover real and true meaning of the statute. What it says, see, legal and doctrinal means what? Legal says about what is actually in the law, actually in the law. Doctrinal says what should be actually in the law, means it is logical. Okay. Doctrinal means when the purpose is to discover real and true. Here, what is the purpose? It is to discover what is the actual rule of law. Legal says about what is actual the rule of law. And doctrinal says whether it is correct or not, it is true or not. You have to discover that thing. Okay. Hence, another thing, another point comes is this legal has been divided into authentic and usual. There is two parts of legal, that is authentic and usual. Okay. What is authentic? Authentic speaks about when the rule is being derived from the legislator itself. Authentic means it is from the legislator itself. And what is usual? Usual is when from the other source, such as custom or case law. So here, if you understand that this legal is being divided into two parts. Two parts. Okay. This is authentic. As you say, as you understand, the word authentic says about what actually the legislator is saying about, derived from legislator itself. Next comes usual. Usual is coming from the before cases done or any custom or any other laws. Okay. But these both are speaking about the actual rule of the law. Got it? So here I would like to conclude one very important thing is legal is means legal or actual. Doctrinal means logical. Okay. So here logical interpretation or grammatical interpretation, logically when you understand or to find out whether that rule or that notification, that order is real or true. Okay. So the grammatical, here the grammatical, when it is grammatical, when the court applies only the ordinary rules of speech for finding out the meaning of the words used in the statute. What is it? It is saying when there is a case in the court, okay, and when that case is saying, when in that case now the court applies ordinary rules, when the court is applying ordinary rules of speech for finding out the meaning of the words used in the statute, it is using what? Ordinary rules of speech. When it is using the ordinary rules of speech and not the actual rule of law, that means it is saying logically, it is understanding in a, it is interpreting in a logical and a grammatical manner. That is called doctrinal interpretation. Got it? I hope you understood. Now, on the other hand, when the court goes beyond the words and tries to discover the intention of the statute in some other way, then it is called logical interpretation. So, what is the brief crux of this thing? Here, this thing which we read now. Classification of interpretation already understood. Ma'am, there is interpretation classified into two ways. First is it is classified in a legal way or it is been classified in a doctrinal way. Ma'am, if it is legal, it means it is saying about the actual rule of the law. And if it is legal, it can be of two parts. It can be authentic legal. It can be It can be usual legal. What is authentic legal? Authentic legal means, ma'am, it speaks about legislature itself, or from which is brought from the legislative itself. What is usual? Which is come from the before cases or any other acts, or like customs and so. Got it? What is doctrinal? Doctrinal is having two parts, ma'am. It can be grammatical in nature or logical in nature. Logical speaks what? It speaks about when the court goes beyond the words and trying to understand the situation or intention of the act, trying to understand whether the act is real or no. That is called logical thinking. And when it comes to dramatical, dramatical comes when it is, ma'am, it's a dramatical situation comes when there is ordinary rules applied in the court, when the court is applying ordinary rules and finding out the real meaning of the statute, then it comes grammatical. So one important point I would like to say, boys and girls, you have to make your mind fully clarify that there are interpretation two ways. Already said you, this is the fourth time I'm saying interpretation two ways: legal or doctrinal. Legal can be of two types: authentic or usual. Doctrinal can be of two ways: it is grammatic or logical. Okay, that's what is given. Okay, please read it. Okay, now question number 6. How will you interpret the term instrument used in the statutes? This is a question which has been asked in our exam, 3 marks question. So how do you write? The question's answer should be written in such way. Do not think that, ma'am, 3 marks you have to write minimum of this much, half of the page. No, not required. Whatever the keywords are there, you write those keywords. Whatever I have underlined in our study mat, if you write that much and properly explain it in a proper and a brief way, and it should be logically correct, then only you get points. Okay, let's understand what is the meaning of, how do you interpret the term instrument? Like, what is the meaning of instrument in this particular statutes? Okay, now the term, it means formal legal document. What is it? It's saying it is a formal legal document. Okay, so it creates, which creates or confirms a right or records of fact. What does it do? It means it is a formal legal document. So if it is a formal legal document, what it does? So what is instrument? It is saying instrument is a formal legal document. What it does? It creates, it confirms a right or a record of fact. It is saying that there is a fact. This instrument is declaring one thing. What is it declaring? It is saying that this particular instrument is giving you a proof that this is something which has been done. It is a fact. Okay, so it is what? It should be obviously a formal writing of any kind, such as agreement. This instrument can be of agreement, it can be a deed, it can be a charter, it can be a record, it can be drawn up and executed in a technical form. Understood? Instrument can be of these types. It can be agreement, it can be a deed, it can be a charter, it can be a record. Now, it also means a formal legal document having a legal effect. Boys and girls, it is obviously having a legal effect. Means, for example, I am showing this particular instrument to the court. That means it is going to resolve the case in some or the other way. It is going to give a legal effect. It is very much beneficial. Either as creating liability or as affording the evidence. It can give legal effect in two ways. It can be two ways. It can give legal effect by creating liability on it, or it can help you in giving an evidence on the particular problem or the particular case. Okay. Hence, what it says, there is an instrument. The meaning of instrument is brought from the Indian Stamp Act, okay, where it declares one thing, that what is instrument? It includes this one. Understanding this is what? It is an inclusive definition. It includes. It is not directly saying. It is just giving you a telling that this is the scope, and it is not giving you the scope. It is saying these are the points which are giving you the meaning of instrument. Okay, so instrument includes every document by which any right or liability is or purports to be created, means which is being coming out or declared to be created, transferred, extended, or extinguished, or recorded. So as per Indian Stamp Act, which has been declared that instrument is an inclusive definition, which includes what? It includes every document by which any right or the liability is being declared, or it is being coming out, or it is being declared to what? To be created, to be created, to be transferred, to be created, to be transferred, to be extended, or to be extinguished or recorded. It can be, this document can be used to be create, this can be used to transfer, this can be used for extension, this can be used for extinction, and this can be used for record. So these are the purpose why the instrument can be used. I hope you understood the meaning of it. Now, okay, let's do this question number 7, and maybe we'll do question number 8, and then we'll end up this particular lecture, and the next lecture we go ahead with our chapter. Okay. Now, this says what? This says about the importance or need of the interpretation. Why is it required? Okay. Why is it required? Importance or need of interpretation. Interpretation, thus, of considerable significance is a considerable significance. In relation to the statute law, interpretation is of the importance because of inherent nature of legislation. Why it is important? Because it is directly coming from the legislation as a source of law, as a reference of law, as a part of law. Okay. So the process of statute making and the process of interpretation statute takes place separately from each other, and two different agencies are concerned. What is it? Interpretation serves as a bridge of understanding between these two. What is it? What is it? First thing, the process of statute making and the process of interpretation statute. These two processes, it bridges the gap between these two processes of making and of interpreting the statutes. This is why this is important. Okay, so it is necessary and it is a need of the need for the interpretation to be done. Okay. Next, interpretation is usually said to be either legal or doctrinal. Explain them. As already we have read it, let's understand it more better. It is legal. When it is legal? When there is actual rule of law, right? And which binds the judge to place a certain interpretation of the statute, which already read it. It is doctrinal when it is giving you real and true meaning. Fine. Already I said you this legal is being divided into two parts, authentic and usual. Doctrinal, is being divided into two parts, grammatical and logical. That's what is given if you read it. Okay, understood? Fine. I hope you have got a clarity on it. So till now we have done is what? Now, if you see this particular point, we have completed what? We have completed deeds, we have completed statutes, we have completed documents, we have also completed what is interpretation. We also read what is the need of interpretation, necessity of interpretation, and we also understood what are the different parts of interpretation, how it can be done. It can be done in logical sorry, how it can be done. It can be done, there are two parts, that is doctrinal, and what is another part which we have read? What is the another part which we have read, boys and girls? It should be there in the tips, man. Logical and legal, or else you can say legal and doctrinal, or else legal is having two parts, authentic and usual. Doctrinal is having two parts, that is grammatic and logical. Fine, we have done this. What is document? What is the main four elements of the document? That's important part to be read. So basically we have completed this particular portion. Okay, later we have these portions to be done. Do not worry, we'll go happily, we'll learn with example, and please enjoy the chapter because it's very very important to be focused on. Okay, till then keep smiling, have have a good time, enjoy life, keep enjoying my lectures. I hope you're liking it very well. We are going with a very slow and a happy way. So tata, keep smiling, bye bye.